You're listening to Audiology. Support our work on Patreon and be sure to submit your requests for topics in the comments below. The Unitary Executive Theory is an important concept in U.S. constitutional law that suggests the president has control over the entire federal executive branch. This idea is grounded in the U.S. Constitution's Article 2, which gives the executive power to the president. While many legal experts agree on this basic idea, there is a lot of debate about just how much power and control the president really has. Stephen Calabresi and Christopher Yu, in 2008, argued that this theory is about ensuring the government follows the law in a uniform way that aligns with the president's direction. On the other hand, scholars like McKenzie in 2008 and Crouch, Roselle, and Sollenberger in 2020 have pointed out that it is crucial for federal workers to carry out laws faithfully, following the procedures set out in the Constitution. Article 2 of the United States Constitution establishes that the president holds the executive power in the United States. Advocates of the Unitary Executive Theory use this, plus the clause mandating the president ensure laws are faithfully enforced, to argue for a single, hierarchical executive branch under the president's command. Initially, this concept was simple and uncontroversial, with the understanding that the president's role was to implement the law. Over time, however, more extreme interpretations have emerged, suggesting the president could act beyond the bounds of the law, especially in matters of national security, without oversight from Congress or the judiciary, as former White House counsel John Dean indicated. Legal scholars Lawrence Lessig and Cass Sunstein acknowledge that the Founding Fathers envisioned a unitary executive, but there is debate over how strong or weak this control should be. The strong version suggests the president has more restrictive control over the executive branch than the weak version. During his Supreme Court confirmation hearing, Samuel Alito appeared to lean towards a more moderate, weaker interpretation. Some experts, however, challenge even this milder form, proposing a shared executive power setup, similar to those seen in several states, or a model where control over the federal bureaucracy is jointly held by Congress and the president. Changing to a plural executive system nationally would require a constitutional amendment, highlighting a fundamental difference in the discussion around the unitary executive theory. It's about the extent of the president's control over the federal bureaucracy, not about having influence, which scholars like David Rosenblum and Francis Rourke suggest both Congress and the president have. Supporters of a strong unitary executive argue that the president should control all aspects of the executive branch, challenging the constitutional standing of independent agencies not under direct presidential control. Despite this, such agencies have existed for over a century and have been recognized by the judiciary. Regarding judicial implications, there's a principle that no part of the executive branch can sue another, based on the reasoning that the executive cannot sue himself, which aligns with maintaining a separation of powers, a core principle meant to prevent one branch of government from encroaching on another's duties or responsibilities. Back in 1787, during the Philadelphia Convention, people were already discussing the concept of having just one person be the president, which was a key point in the Virginia Plan. The opposition, presented in the New Jersey Plan and supported by figures like Elbridge Gerry, Edmund Randolph, and George Mason, suggested having multiple executives or a council instead. James Wilson, at the Pennsylvania Ratifying Convention that same year, laid out the advantages of sticking to one chief executive. He highlighted that with a single president, there's better accountability, energy, decisiveness, and overall responsibility. He explained, "The executive power is more trustworthy when it doesn't have anywhere to hide. Our president is fully accountable and can't just blame others for his mistakes or hide his failure to act. Every nomination he makes, he's responsible for, ensuring that we maintain energy and decision-making capability that you just wouldn't see with multiple executives. This high-ranking officer, despite wielding significant power, doesn't have any special privileges and is subject to the laws just like anyone else, accountable both as a citizen and in office through impeachment." In 1788, someone writing under the pen name Federal Farmer defended the idea of having just one person oversee the execution of laws, arguing that a single person is perfectly positioned to handle this job with clarity, speed, and consistency. Additionally, Federalists like James Madison pointed out another advantage to having a unitary executive. In Federalist number 51, Madison argued that a single executive would be more effective in preventing the legislature from overstepping its bounds because, the weakness of the executive may require that it should be fortified. Alexander Hamilton later weighed in, noting that the Constitution defines legislative and executive powers differently. Congress has specific powers which are clearly listed, but the president's powers aren't spelled out in the same way. Hamilton believed that the Constitution intended for executive power to include certain responsibilities by implication, not limited to an explicit list. This gave the president a broad scope of action, in line with the Constitution and the principles of a free government. Furthermore, he mentioned that although Congress has the sole power to make laws, which the president is supposed to enforce as long as they're constitutional, the president still needs the freedom to exercise executive powers effectively. The Constitution allows Congress to enact laws necessary for the government's operation, emphasizing the balance of power, where both Congress and the president must be able to exercise their respective powers without overstepping. In the 1926 Myers v. United States case, the Supreme Court of the United States clarified that the president alone has the authority to fire officials within the executive branch, without needing to get the green light from the Senate or any other part of Congress. The court emphasized that the president oversees the work of these officials due to the broad executive powers granted to him. This allows the president to ensure laws are applied consistently and effectively, aligning with the Constitution's vision of singular executive leadership. Following this decision, other cases like Humphrey's Executor v. United States v. Nixon, and Boucher v. Senar have further explored this principle, sometimes expanding or limiting the extent of the president's power. In an interesting twist, Justice Scalia, in his lone dissent in Morrison v. Olson, argued that the president should have the unfettered right to dismiss any executive branch official, including the independent counsel, a notion the court initially rejected. However, the court's later decision in Edmund v. United States seemed to inch closer to Scalia's point of view. Professors Carl Mannheim and Alan Eides from Loyola Law School explain that the separation of powers among the government's branch, the executive, legislative, and judicial, is not meant to be completely separate. They use the president's veto power as a prime example of how the executive branch has a say in legislative matters. They point out that while the executive branch does have some powers that seem legislative or judicial in nature, which are essential for the government to function properly, the foundation of all administrative authority really falls under Congress, not the president. According to Mannheim and Eides, the president's true powers are strictly those outlined in the Constitution, a viewpoint shared by scholars Lessig and Sunstein. David J. Barron, now a judge, and Marty Letterman also expressed doubts about the theory that suggests the president should have absolute control, especially outside of the military context. They argue that if the Constitution intended for the president to have such broad powers everywhere, not just as the military's commander, there would be no need for the specific laws naming him as such. Interestingly, the U.S. Constitution does not specifically address emergency powers or state how and when they can be declared, unlike the constitutions of many countries. Yet, some legal experts believe the president has inherent emergency authority through his role as commander-in-chief or through vaguely defined executive powers. Congress has passed laws giving the president 136 emergency powers that can be activated if he declares an emergency. Most of these do not require Congress's approval to activate. These powers are vast and can include extreme measures like taking over the internet or declaring martial law. This situation has concerned some, noting that in the wrong hands, these powers could be abused to gain more control, echoing Justice Robert H. Jackson's warning that such powers are like a loaded weapon for any leader claiming an urgent need. It's a misconception that the concept of a unitary executive began with George W. Bush's presidency. Ronald Reagan referred to this idea in a 1987 signing statement, asserting the president's supreme authority within the executive branch. Bush did, though, frequently invoke this theory in his signing statements, such as with his stance on how to treat detainees, claiming it as part of his constitutional duty to oversee executive branch decisions and assert military command, although critics argue he overreached, particularly in his attempt to override judicial decisions. In some states, unlike the federal government, key executive roles such as the lieutenant governor, attorney general, comptroller, and secretary of state are elected on their own, not tied to the governor's election. This setup is referred to as a plural executive. Texas stands as a prime example of a state that employs this kind of structure in its executive branch. In North Carolina, there's likewise a plural executive system in effect. What's notable here is the inclusion of a group known as the North Carolina Council of State, comprised of elected executive officials. This council is pivotal, especially in terms of approving financial and property transactions of the state government. It serves as a mechanism to ensure that the chief executive, or the governor, doesn't monopolize all the power. The concept of a plural executive is not exclusive to the United States. Nations such as Japan, Israel, Italy, and Sweden exhibit similar frameworks. However, in these countries, the operation of the executive branch varies slightly. Rather than featuring multiple officials elected independently, these nations have a collegial body that resembles the cabinets observed in the US or the UK. This assembly does not consist of members elected directly through elections, but is established and organized to function akin to a team, collaboratively managing the executive responsibilities. Thanks for watching. Share your thoughts in the comments and subscribe for more content.